Welcome everyone to the Module 1 live session for the contracts course. This is PL 140. I'm Catherine Dove. I'm going to be your instructor for the next 5.5 weeks. We are going to have an introduction to contracts, talk about some of the most relevant contract principles. We're going to learn how to form contracts. We're going to learn how to write contracts. We're going to learn how to identify contracts. We're going to learn how to execute, perform, and enforce contracts in this 5.5 week course. We will also be talking about the Uniform Commercial Code, which is a set of laws that apply to contracts for the sale of goods. So let's get started. When is the last time that any of you had to deal with a contract? You can type the answer in the chat box. When is the last time that any of you had to deal with a contract? When is the last time you saw a contract? Because contracts are in our daily lives. Adrian said, when a client hires my company, exactly. Contracts for services, contracts for the sale of good, contracts for the sale of land. Yes. Contracts for the purchase of a vehicle. Sometimes it's an installment plan where you pay. Yes. Tina said a few years ago, I refinanced my home. Yes, for renting your apartment, that is a lease. It has very specific provisions. Yeah, lots of papers to sign for the car. So yes, there are written contracts, there are contracts for talent, contracts for professional athletes, contracts for Taylor Swift and musicians. There are service contracts, there are African tribal contracts. In England, there were actually contracts for marriage. Those are void against public policy in America, but we still have, prenuptial agreements. So there are all types of contracts in our daily lives. And as professionals, you really need to know what those contracts are and how they're enforced. As paralegals, from time to time, contracts will be coming across your desk. You will have clients who need your assistance enforcing a contract. So contracts are very important. Most of contract law is governed by what's known as common law, and that's simply judge-made law that comes through cases. Every time a court hears a case about a contract, that decision that the court renders becomes a judicial precedent, and that precedent is a rule of law that has what's known as stare decisis, which means let the decision stand, so that we are building on a body of law. Every time a decision is rendered, that decision does not change the law. It simply follows the law. So that when we do research and we want to know whether an oral contract is enforceable, we can get on Lexis Advance or Fastcase and research oral contracts and come up with a list of case citations where the enforceability of an oral contract has been determined by a court. That is a judicial precedent that we can cite. So that is how our legal system works and how judges make law, and they make law in the area of contracts. So what is a contract? A contract is a promise or a set of promises for which breach is the remedy. It is an enforceable set of promises. We make promises all the time. Sometimes you may tell one of your friends, I promise to drive you to the mall. Is that enforceable? Kara, if you tell your friend, I promise to drive you to the mall, but you never get around to doing it, can your friend sue you?
No, they can't.
Why not?
It's not written. You're not signed. You're not set in stone.
Contracts do not have to be in writing. Oral contracts are perfectly enforceable.
What?
Yeah, contracts do not have to be in writing. We like,
Okay.
as legal professionals, we would like to have a contract in writing, But oral, as Jody put in the chat, oral contracts are perfectly acceptable. However, there must be something else known as consideration. So there's three elements of a contract. One is an offer. One is the other party accepts the offer. And the third is consideration. So if I offer to drive you to the mall, before a contract can be enforced, you have to accept that offer. And there also has to be something of legal value that's bargained for. So if you say, okay, I accept your offer to drive me to the mall tomorrow, and I'm paying you $10 for gas, and you give me $10, that's a contract because there's an offer to drive you to the mall. You accepted the same terms of the offer, and you provided consideration, which is something that is bargained for. You know, I wanted $10, you wanted to be driven to the mall. We exchanged promises, and there was an exchange of consideration. So without any writing, pens, paper, or any of that, people were bartering long before they had paper, before they knew how to write anything, before they had pens. People were bartering for goods. You know, I'll exchange this calf for your donkey. I'll exchange this cornmeal for your rice. So throughout the ages, people have been bartering and exchanging goods well long before they had, you know, fancy pens to write with. So oral contracts are enforceable. However, you must have an offer, which is an expression of an intent to be contractually bound to specific and definite terms. The other party has to accept it according to the same terms, and then that consideration, the thing of legal value that's bargained for. So when you purchase a car, that's a contract because the dealership offers to sell the car. You accept that, and promise to pay for the car according to the terms you all agree with. Sometimes you have to haggle for your cars. You know, I go to the same Ford dealership here in town whenever I want to buy a car. First time I came in, they were all high pressure sales, so I just walked away. They called me back the next day and they said, "Do you still want to buy that car?" I said, "Maybe." They said, "Just give me a price, any price. I'll take anything," you know. And you know, if I said I'll give you $10,000 in cash, that would be me making an offer. And if they said, okay, we'll just drive over to the dealership and we'll sell you the car, that would be acceptance. The consideration would be me getting the car and them getting the $10,000. So there has to be a mutuality of promises, a mutuality of obligation, and each party has to get consideration. So that's why on the contract for a sale of a vehicle is enforceable because there's an offer to buy the vehicle. One party accepts that by offering to pay, agreeing to pay, and then they each get consideration. One person gets the car, one person gets the money. So that's a valid contract. It'd be nice. That contract does not have to be in writing to purchase a vehicle. It would be nice if it was, because then it'd be easier to enforce in the event that the buyer drives home and doesn't pay for the car. But that contract can still be enforced without a writing, as long as there's offer, acceptance, and consideration. Why? Because the American law is historical. It was brought over from England, and the history of the law is what remains. The technicalities and formalities of e-contracts and having something in writing and disclaimers are just technicalities. It's the basic common law. Our legal system was adopted from the English common law, and it was brought over here when the pilgrims came. And that is the set of the legal system that we have is based on the common law and very old principles. Contract is a very, very historic and old principle. That's why it doesn't have to be in writing. It just has to be an offer, acceptance, and consideration. Any questions?
I have a question.
Yes, ma'am.
Sometimes you can't prove a lease, like an oral contract. because that's almost sounds like a he said, she said type thing. And when you go to the judge saying he said this and then she said that, you can't prove that. And it's not
Okay.
like you can videotape it because that's against the law in Florida too.
This meeting is being recorded. Just let everybody know that for the benefit of your classmates who are not here, or if you want to watch it again. This meeting is being recorded. So, how testimony works is in a court of law, and you will learn this in your civil procedure and your evidence classes, is witness testimony is perfectly acceptable. Watch court TV. That's a great way to learn um, about how the law works. Court TV, court reenactments. In court, the court hears evidence. Evidence is a witness talking because judges have the ability to determine the credibility of a witness. I can make a statement in court, and if the judge believes me, that's evidence. That's as good as a document. If I go into court and I say, I had a contract to purchase a vehicle, I gave the salesman $10,000, but the vehicle was never delivered. If I am a believable witness, that's evidence. That is enough evidence to prove, but by a preponderance of the evidence in a civil matter, the burden of proof is only 51%. It is not beyond a reasonable doubt. That is for a criminal case. So a civil matter, not criminal. You only need to prove your case by 51%. So if the judge believes my testimony is good enough to prove by a preponderance of the evidence an existence of a contract. Why? Judges and lawyers are taught how to read body language. If I could see you and look into your eyes right now, I could read your body language and I would know if you're lying. So judges know, judges and juries can tell if people are lying. If somebody has inconsistencies in their testimony, if someone is nervous, if someone has a history of lying or stealing or other acts that weigh negatively on their veracity or their credibility, all of that comes into court. So when a witness testifies, their honesty and integrity is on the witness stand as well. So as long as the judge believes that your testimony is accurate, then that is evidence. And if you want to know how that plays out, watch Judge Judy. Has anyone ever watched court TV? Judge Judy is one of the best because she'll tell you you're lying, plaintiff and defendant. I think you're telling the truth, and I think you're hogwash. Judge Judy will tell you what it is she thinks, and she, as the judge in a bench trial, is the finder of credibility. And if she believes that one person is lying and one person is telling the truth, she can base her decision on what she feels is the honest testimony. So that is why an oral contract is enforceable, because people like me, I know how to read body language. I know how to, again, I know how to look into people's eyes and see things and et cetera, et cetera. People get trained to do that. It's human psychology. People do certain things when they lie. And anyway, a good judge or a good jury can tell when someone's lying. You'd be surprised. People think that they can lie and get away with it, but you can catch people in lies. And again, you see that if you watch court TV. So that is how an oral contract is proven. It's proven through testimony, the testimony that the judge believes is honest. And there still are some honest people. Like I personally almost never lie. I'm not going to say when I was a teenager, did I tell a few fibs every now and then? Sure. But as an adult, I don't lie. I find the truth much more interesting. So, if I go to court and say something, the judge is probably going to believe me because I'm going to look the judge right in the eye and I'm not going to blink. And I'm just going to say, hey, judge, I grew up in the backwoods of Virginia. I don't lie, and this is what happened. So if the judge believes me, then that is good enough to prove by a preponderance of the evidence of whatever I'm trying to say in court. Any other questions? That was a good question. As you can see, I can talk forever. So let's get back to oral contracts. Contracts may be written or oral. We know because of the he said, she said problem. Written contracts are easier to enforce. You can even bring a text message into court now. You can bring an email into court. You can show Judge Judy, hey, here's a text message where he promised to do X, Y, and Z, where my landlord said he would fix the broken faucet and he would deduct and take this money off my rent, and he didn't do it. You can bring that text message in and show Judge Judy. You can bring an electronic lease in. So it is certainly easier to enforce the terms of detailed contracts with a writing, right? But even if you don't have a writing, good old-fashioned testimony in our system of justice works. Let's look at the most basic example of an oral contract. Has anyone here ever paid someone to mow your lawn or to take care of your yard? Have you ever paid anybody to maintain your yard? Everyone here mows their own grass, rakes your own leaves. Okay, Adrian said kids. Yeah, that's usually how it works. So when I grew up, again in Virginia, there were people who would make money on the weekends, students, by mowing the lawn. You know, back then in the 70s and 80s, it was $10. You know, we'll mow your lawn for $10. And some adults, some retired adults have businesses where they will go around and, take care of their neighbors' lawns and charge $50 or something. So suppose Anne talks to her next door neighbor's son, Bob, and asks Bob if he will mow her lawn for $20. Anne has reached a certain age where she ain't gonna be out with no lawnmower. Okay. And Bob doesn't say anything back, but he grabs the lawnmower, pushes it out of the garage, puts some gas in it, drags it over to Anne's house, and starts mowing her lawn. Kara, has a contract been formed?
Yes.
Good. That would be an oral unilateral contract. Unilateral simply means one promise. So a contract is a promise or set of promises. And promised to pay Bob $20 if he would mow her lawn. Now, rather than saying, I promise to come over tomorrow and mow your lawn, Bob took the initiative to just start mowing. That is accepting an offer by rendering performance. So that is a unilateral contract, one promise, and the other party immediately performs. A contract is formed and made a valid offer with specific and definite terms. Bob could accept by promising to mow the lawn later or just mowing the lawn. Kara, what is the consideration in this oral contract?
Gosh. Well, they both. Okay, so thank you. Money.
Yes. Each party must get consideration for a contract to be enforceable. Bob got money. That's something of legal value. The American dollar is not yet worthless. It is still worth something. So as long as American money is worth something and you get some as a part of a contract, that is consideration. What did Anne get?
Her lawn mowed.
Exactly. And that is worth something. That is a service that's been provided that has a value. So as long as each party receives something of consideration, that's a contract. It does not need to be in writing because of our English legal tradition. Okay, so let's get specific. The basics of a contract, the offer. A complete offer contains a promise of future performance. I promise to pay you $20 if you promise to mow my lawn. A description of the terms, what each side gets, and a way to determine when each side has to perform. So just to recap, you need to know the elements of a contract. They are three. Nicole, what are the three elements of a contract?
The three elements of the contract is the offer, acceptance, and consideration.
Great. Do you know how many people in America know that?
Yeah, I was gonna say that because I just learned that today.
There you go. See, this is the beauty of higher education, folks. Knowledge is not just so that you can get a piece of paper and make more money. Yeah, that will happen, but it is to benefit and enrich you. Yes. There are so few people that actually know that the more you know, the better you're going to be when you're dealing with others. Knowledge is power. You hear about, if a woman goes by herself to buy a car, they're going to take advantage of you. It is true. Or if a woman goes to a mechanic, they're going to take advantage of you. Some will do that, some won't. But if you have knowledge, it's a lot harder for them to take advantage of you, right? And even if the knowledge is just, I want to get the contract in writing, I want the mechanic to give me an estimate of what he thinks is wrong with my car and how much he's going to charge. I want to get that in writing. That alone, that knowledge gives you more power in that transaction because then the mechanic already knows he can't play you. There's certain instances, well, sure, if you're going to buy a car, go see a mechanic, take your husband, your brother, your friend, another woman with you. That way it's two against one, because there are definitely instances where people will take advantage of someone who is young or a female. Has anyone ever experienced that when you're in just a commercial business transaction, like buying a car or getting a car fixed, where you felt like someone was taking advantage of you as a woman? Have you ever experienced that?
Many times.
Mm. Yes. So, once you have knowledge, it's going to be a lot harder for them to play you. Do you think if I need a new car now, I'm just going to let the dealer intimidate me and tell me I've got to buy everything according to his terms? Or, like the first time I went to Ford, them just saying, try to pressure me to buy the car right now. No, I'm going to walk away. I'm going to think about it. And then I'm going to let them call me back a week later and start begging. And then I'm going to tell them what my terms are. If you want me to come back to the dealership, you need to, like, I bought a car once that was used, and the prior owner had been a smoker. The car was beautiful, but it smelled horrendous. And it smelled like the person just lived off cigarettes. And I don't think the person did. I was like, yeah, I will buy the Ford because I like the car, but you're going to have to do something about the smoke that's been in that car for 5 years. It's been all sealed up. And then it was like, okay, now I'm getting some of the things that I want, and I'm not going to pay more than X amount of dollars for the car. And when I pick it up, I want to have it full of gas and I want to have it clean. And it's the knowledge that allows me to do that, because believe me, when I was younger, didn't have a college degree, sure, I was a woman, that could easily, in a business situation, somebody could take advantage of you. And you see it all the time. When you go to stores, they try to sell you an extended warranty. Nobody in my family buys the extended warranty because you never use it. You buy a drill at Lowe's. If that drill breaks, you take it back to Lowe's. That's breach of warranty. And it's a sales contract. You have your receipt. You take the drill back to Lowe's. You don't need to buy an $80 extended warranty on a $50 drill, but they have people doing it every day. I mean, my uncle, my cousin, they don't know a lot. They have money and they make a lot of money. They buy extended warranties. And I'm like, what? Are you crazy? That's just them getting over on the fact that you don't know. So we will talk about warranties this term also, so that you are aware. So this is what knowledge does. It makes you a better bargainer in these daily contracts, because contracts are in our daily lives. And you don't want to be on the bottom end of that deal, the one who gets taken advantage of. You want to be the person who walks away from the deal smiling because you got what you want and you didn't get played. And the only way to do that is with knowledge and experience. So the first thing is knowing what is a contract, what's happening here. It's offer, acceptance, and consideration. And again, it would be ideal if you could get that in writing, especially as legal professionals. And that's what we're going to be looking at our Module 1 assignment. Let's talk about this. So Enforceable offer, price, consideration, and definite terms. Let's look at a scenario. It's a very common scenario. It is a contract for repairs on a home. This happens every day. Imagine Bill is a contractor. He wants to be hired by two homeowners, Ron and June, to paint their house. All of the terms are actually oral because, again, this tradition in society of people just chit-chatting, hey, I'm a contractor. You know, your house needs to be painted. You know, I've had people approach me, you know, about things like that. Oh, did you know your car, you know, could use a touch up? And I'm a contractor. See my truck. And I'm like, I'm not interested. I'm not going to be taken advantage of in that way. But some people will go ahead and do it. They're like, oh, okay, you're a contractor. Yeah, my house does need to be painted. So in this scenario, Ron writes down, I'm sorry, Bill is the contractor. He writes down one thing: paint Ron and June siding on their house, $1,500 for labor. Homeowners will pay for supplies to be completed by the end of the summer. Nothing else is written though. Everything else is them orally chit-chatting, you know, certain terms are just implied by society. One, there's an implied covenant of good faith, good workmanship, good, you know, good dealing. So, you know, Bill is to scrape and paint with a primer and use a finish coat. That would be implied in any paint job. He must use a paint that, of course, the homeowners like. He can't use a paint that's green that they won't like. Even if that's not in the contract, he's got to use a reasonable quality paint, one that looks decent and presentable. Bill needs to bring his own ladders. So, do you think there's a legally enforceable contract here, Jody? I'll ask Adrian. Okay, I see it. You typed it. Yes, yes, there is, Jody, because all you need is offer, acceptance, and consideration. So if Ron and June, the homeowners, agree to allow this contractor Bill to paint their house for $1,500, and you know, they each make a promise. I promise to pay you if you paint my house, and Bill promises to complete the job. That is an exchange of promises. There's an offer. If they accept his terms, the consideration is the money, something of legal value, and getting the house painted. So offer, acceptance, consideration is met. That's a legally enforceable promise, even though all of the terms are not written. Only thing that's written is just Bill jotted down, paint Ron and June siding on their house, $1,500 for labor, homeowners to pay for supplies to be completed this summer. If Bill wrote that on a napkin, do you think that would be enforceable, Tina? If Bill wrote that statement on a napkin? How about if he wrote it on the back of a receipt? Yeah, it's still enforceable because of the history and the tradition that is in American common law. Obviously, these days, you know, someone would at least want to receive that in an email, you know, a text message, something to evidence the existence of an agreement. But it is still enforceable because they'll just simply go to court and testify. Even if you didn't have it in writing, you can still take pictures of the house, what it looked like before, what it looked like after. So let's suppose that Bill has gone ahead and painted the house, and that Ron and June went to Las Vegas and spent all of their money on vacation and lost it gambling. They come back home and they still haven't paid Bill. This happens every day. So Bill has to file a small claims court action and go before Judge Judy and say, look, Judge Judy, I am a contractor and I had an agreement to pay Ron and June's house. And Judge Judy says, okay, where are your pictures? Do you have a picture of the house? Do you have a picture of the paint that you bought? Do you have a picture of you doing the work? Do you have a picture of the ladder? What evidence do you have? So even if you don't have all of the terms of the contract in writing, again, you would testify, you would bring whatever evidence you've got, and then Judge Judy would decide, is there enough here to find a legally enforceable agreement, and is there enough here to render a $1,500 judgment for Bill? And in this situation, with what we're looking at, yes, there is enough evidence here of an enforceable contract that Bill is entitled to $1,500, and I think Judge Judy would happily rule in his favor. Any comments or questions about this scenario? All righty, let's keep going. Okay, so let's take a look at our Module 1 written assignment. And for this, I'm going to share my web browser with you so that we can go into the online classroom and look at the details of the Module 1 written assignment, since this is the assignment that you will be graded on. So Firefox is installing your updates. Looks like I'm going to be using Firefox. So we are going to go into Blackboard, which is our learning management system. It is already spring term 2021. Going under Module 1, an introduction to contract law, which is what we are having right now. Let's take a look at the scenario presented in this assignment. Complete oral offer. So what you're going to be required to do here is to consider a scenario where a paralegal is sitting down and talking to clients. And the client is a homeowner, and this is what your client, June, tells you. So we're supposed to tell you what happened. Leo, the owner of Riverway Construction Company, said he would re-roof our one-story house for a lower price than anyone else. We showed him a bid from a competitor that we thought was a good bid, but when he studied it for a while and smiled, he didn't know why. We didn't know why he smiled, but what do but we think we do now. So Leo, the contractor, saw another bid and he thought that was funny. So the paralegal says, well, what happened? The client says Leo and his construction crew agreed to do the roof for $6,500, which was $800 less than the other bid that we got. My neighbor witnessed this statement, and he noticed that Leo was looking at the other bid. The bid included soffits and fascia. June, the other homeowner, says, anyway, we're not satisfied how this worked out. We saw what he did. The roof is not what we wanted. The soffits and the fascia were not done. Unlike the other contract's written bid, we should have had him do his own bid, but he just started working right away, and we were so busy we forgot. So, okay, Leo never gave a detailed bid explaining exactly what his company would do, but because human beings are what human beings are, the homeowners allowed Leo to do the work just because he used his, personality and his manipulation, and said, "Oh, you got this bid from this guy. I can do the work for $6,500, which is less than this other bid. Let me just go ahead and get started." And the homeowners, probably wanting to be polite, were like, "Oh, okay, great, go ahead and get started." But then they weren't happy with the work. And now they don't have a detailed document which explains what it is that Leo, in fact, promised to do. So the paralegal says, "Well, I'm only here to gather information. It's the attorney's job to give you advice. I'll report to the lawyer and make an appointment for you to visit with the attorney, Bridget Johnson, about this." And then they both go on talking at once, and this is what they said. The soffits and fascia were not done. He won't come back and do them. And then the paralegal says, "Well, what about the roof? Was a good steel roof put on?" "Yes." "Was it about the same quality?" "Yes." And then the homeowner says, "We weren't paying the labor and materials invoice he sent. We forgot which is soffits and which is fascia, but they're below the roof, and we wanted them done at the same time the roof was done, June, or anyway, even if not, that's what he said he would do." He said roof, but he meant to match the bid, but at a lower cost. The first lawyer we talked to on the phone said we had a case, but didn't take the case. Now, why do you think a lawyer would tell someone on the phone that you have a case, but did not take the case? Why do you think that would happen, Kara? Lawyers are sneaky people. I try to avoid them at all costs, unfortunately, because I am one. I can't always avoid them. But why would a lawyer talk to a client over the phone, listen to their scenario, and say, "Hey, you got a great case, but I can't do it"?
Well,
Why would a lawyer? Mhm.
to give the lawyer the benefit of the doubt, it could be it might not be beneficial to them, or they might have a conflict of interest issue. They might have already taken the other client.
What are lawyers known for?
Scamming people.
What else? Okay, the practice of law is a business. What are lawyers after?
Money.
Exactly. The attorney probably did not see enough money in this case. Some lawyers want to charge $500-$600 an hour, and if the clients had to pay his rate and they only get $6,500 out of the contractor, and the attorney is looking at how much time he would have to spend going to court on something like this might cost the attorney $2,000, you know and then
Right.
the clients have to pay him. So for him, he doesn't see enough money in it.
Trying to be nice.
Yeah, you have a case, but you don't have one that I'm going to take because one, I'm too busy. Two, I need to make money, 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 money. And even if you were to pay me $2,000, that's not enough for me to pay for my office, for my paralegal, for the electricity, blah, blah, blah. So this lawyer does not see enough money in the case. So anyway, the homeowners have gone to Bridget Johnson, and Bridget Johnson has them talking to her paralegal. Bridget Johnson is willing to take the case. So let's get down here to what the paralegal Helen is asking them for. So based on, and just to let me wrap up the scenario, our neighbor Dan Webster was with us the whole time. We talked to Leo, so I'm guessing he might be kind of a witness. And June says, by the way, Leo left a major mess for 2 weeks before he cleaned it up. The bid from the other guy so that the mess would be removed in 1 week or less. So if you're the paralegal, what more information do you need from your client? How would you approach this case, Kara? What would you do if you were the paralegal? Your boss is going to take this case on. What information do you need from the client?
Um, you would need all the evidence. You would need the client's names. Um, how much they spent on, you know, the roofing stuff, and maybe pictures if they have it.
Good. Pictures are going to be very important since they're saying that the contractor did not complete the soffits. He left a big mess in their yard. They weren't happy with the work. They're going to need some photos, right?
Yeah.
But what about their neighbor? What do they need
Oh,
for the neighbor to do?
they also need dates. Sorry. For the neighbor, they're gonna need them to testify because they were a witness.
Good, good. Yeah, witnesses are invaluable. Because a judge and a jury um can tell whether someone's telling the truth or whether they're lying, you know. There'll be inconsistencies in somebody's testimony if they're lying. It won't make sense if someone testifies and they're lying. The whole story just won't make sense. You can get an icky feeling about people when I mean, there's so many ways to tell if someone is lying. So, yes, a witness is invaluable in a scenario like this. I'll just give you an example. I would say, like 10 years ago, my brother was leaving his neighborhood to go to the store, and he was pulling out into the main road, and a Mustang came zooming by and hit his car as he was trying to inch out into the road. And a couple of senior citizens were out taking their afternoon stroll and saw the whole thing. So when my brother had to go to court with, you know, his insurance company, State Farm, was representing him, and the other driver of the Mustang was in court also. The neighbors the witnesses who saw it said that guy in the Mustang was driving really, really, really fast. So who do you think won? Who do you think won? Yes, my brother won, and you know, that's just how it is. And if that you just cannot underestimate the power of witnesses, and people are always watching. You know how nosy your neighbors are, you know. Sometimes when my neighbors are out walking their dogs, they got a little flashlight and I see their flashlights shining into my window. You know, I'm wondering what they're looking for. But you know how nosy neighbors are. There's always someone watching, you know. We've seen that with all these instances of police brutality and police excessive force. You know, for a long time, the cops got away because nobody had a cell phone camera. Now people are standing there watching them with a cell phone camera, and that's evidence. So, yes, if you have a witness, you can win your case. That is the power of oral testimony in court. If the judge believes your witness is a decent, credible human being, you can win your case based on that witness. So, yeah, the fact that the neighbor was a witness would be very helpful. Can everyone hear? Awesome. So, what you're going to be doing is writing a paper. In your own words, one, recommend why an attorney, explain why an attorney might recommend that an oral contract be put into writing, even when an oral one is still enforceable. And there are plenty of witnesses. Let me go back into the classroom. No, I need to stay here. Okay, so these are the questions you need to answer. Comment personally on the transcript of the client interview. How would you feel about the way that the paralegal did the interview? Could the paralegal have done something better in interviewing the client? And that's going to be your opinion. If you were the person doing the interview, would you use a pre-printed intake form and just mark certain things off with handwriting? What other methods can you use when you're interviewing a client? So some of these questions are great because they allow you to think and allow you to speak your own words. What would you do in this scenario? Just put it in your own words. How would you approach interviewing a client? 3, recommend 3 open-ended questions to ask the client at a follow-up interview, and 2 questions asking for what kind of documents you might need from the client. Open-ended questions I'll get to that, Jody. Open-ended questions are really a way to get information out of a client. Like when you, again, if you watch court TV, you can learn so much. When a witness is on the stand and the attorney says, "What happened next?" That's an open-ended question. That's just trying to get some facts out there before the judge and the jury. It's a lot different when the attorney says, "Well, you really weren't there, were you?" That's what they do on cross-examination. That's a leading question when the opposing counsel is trying to get the witness to say what they want. But an open-ended question is very broad. What did you see? What did you hear? Who else was there? So come up with 3 open-ended questions that you would ask these homeowners in the next interview. Okay, that's okay, Kara. It's being recorded. Um, Based on what you know so far, was the oral agreement based on a complete offer or an incomplete offer? So this is where you'll need to cite to some references and you'll need to cite to some cases about contract law. You can cite to this live session PowerPoint slide. You can cite to the lesson notes. You can cite to your textbook. So number 4, based on what you know, was this oral agreement to put a roof on Ron and June's house? Is that a complete offer? Specify areas of uncertainty. You do not have to use this application table, Jody. You don't. If you would like to use it, you can. You don't have to. I found it to be confusing. Some people think in different ways. Yeah, some people, you can use it if you think it would help you. People think in different ways. Some people think in a way that's linear. Some people think in a way that is more spatial and associational. Depending on how you think, this application table will not help you. If you would like to download it and use it, I'm going to let that be a discretionary decision up to you. You can answer these questions without using that application table. And whatever stance you take, Adrian, you'll just want to make sure you support that with the theories from the textbook. So with every assignment, there is a grading rubric, and I want to show you the grading rubric. By looking at the grading rubric, you can see what criteria should be met in your paper. The importance of writing, of having it written, of a written contract. Make good and clear use of the lecture notes. Show personal ideas clearly. Provide ideas about why lawyers push for written contracts. If you talk about why lawyers would prefer things to be written and contracts to be in writing, that's 16% of your grade. 33% of your grade. Discuss the interview, how to report, which is how you would document what the client has said during the interview. Create open-ended follow-up questions. Explanations show a high level of interviewing ideas. Question shows insight. And the open-ended questions. What did you see? What did you hear? What happened next? Open-ended questions. Complete or incomplete offer. Did you do a good job of arguing both sides? So always understand this, and this is why there's so much confusion in the world. There really are 2 sides to every story. And when an attorney is arguing a case, you may need to go into court on day 1 and say, "Your Honor, there was no contract." Day 2, something may happen and you get a ton of evidence that shows that there was a contract. Day 3, you might have to flip sides and go into court and say, "Your Honor, there was a legally enforceable contract." So you have to be prepared to argue both sides. You have to be prepared to see both sides, because nothing is black and white. despite our society's attempt to make things black and white, because it's much easier to make a snap judgment, that is not how things are in reality, though. It's easy for people to say that's right, that's wrong. But once you analyze, once you, one, learn the law about what an offer is, two, apply that to the facts, you'll see that there is room to make an argument on either side. And a good paralegal, a good legal professional can argue either side, because I'm telling you, things will happen where day one you think it's an offer, and day two your boss tells you you need to argue that there's no offer. And you better understand what you need to say to make it look like there's no offer. Because again, everything's a point of view, right? Somebody tells you that they like chocolate ice cream, and you tell me that you like vanilla ice cream. Who's right? You know, some days I do like vanilla. Sometimes I like to swirl. You know, have you ever been to Dairy Queen where they can swirl the ice cream? So yeah, there's sometimes there's no right or wrong answer. Who would be the one who decides whether it's right? Right? I can't tell you how many times as I've gotten older and become more educated, I realized that what I thought was true was just an opinion, was not factual it was not true according to the facts. And if you have an example is the vaccine, right? You've got friends that are for the vaccine. You've got friends that are against the vaccine. You've got friends that have gotten the vaccine. You've got friends that won't get the vaccine. Where's the truth at in that? Is it a matter of opinion? And can you argue both sides? So a good legal professional can argue both sides, right? Because there is room for interpretation. That's the beauty of the law. That's how lawyers make money, because there's room for interpretation, right? And that is how the contractor is able to get a lawyer, and he hires his lawyer, and his lawyer comes in and tells his side of the case, and then the jury decides who's right and who's wrong. There's room for interpretation, whether it's a vaccine, whether it is whether or not the US should go to war, whether we should be in Afghanistan, whether we should be in Iraq, whether this is or is not a contract. There is room for interpretation. And you have to really recognize that if you want to be successful in the law is not black and white. It isn't. It may seem like it is. Once you start applying the law to the facts of your case, you'll see that there's a lot of room for interpretation. Human beings' brains do not work the same way. They do not see the same information. Some human beings' brains block out information. So you need to be prepared to argue both sides. And I did not come up with this assignment. I'm simply the one that will be grading it. And the rubric is telling me that I need to see a highly effective job arguing both sides about whether the offer was or was not incomplete. Effectively bolster the answers using the lecture notes from the course. You do not have to use that table. You do need to cite to what an enforceable contract is, what an enforceable offer is. You can get that information from your textbook. As legal professionals, I'm telling you right now that judges laugh if they see typographical errors, because some judges are very old, and when they went to school, everybody knew how to spell. Nobody was, using acronyms. There was no BK, no KFC, none of this. You learned how to spell. You learned how to use semicolons and colons and commas where they belong. So you need to check your spelling and your grammar. You can sign up for Grammarly. I believe that the editor that is in Microsoft Word, the spell checker there, will find the majority of grammatical errors and point you to a correct solution. Be sure to run spell check. It also helps to proofread, because sometimes what you think is not the same thing as what you type on a piece of paper, okay? The way the brain works. You see what you want in your mind, but it's not always what's on the piece of paper. So after you've written something, be sure to read it back, or have your friend, your mom, your spouse, your doc, have somebody read it back to make sure that that communicates what is really in your head, because sometimes it doesn't. Again, Blue Book citations. Is everyone familiar with Blue Book citations? Blue Book citations are how you will cite to Here's the blue book. This is how you will cite to your cases. So everyone's familiar with the blue book. And at Rasmussen, we use the Indigo citation. And I'm going to pull that up really quick before we wrap up this live session. We're going to look under tools. Actually, it was in the assignment, wasn't it? The link to it, I think, is in the assignment. There we go. Blue Book Standards. The Indigo Blue Book. It is a way of citing to statutes, treatises, cases. We use the Indigo Blue Book here. You click under cases. That's mostly what you'll be citing to in this assignment. You could cite to a treatise about contract law. Just to show you what a treatise is. Just so happens I have one and it's very old and dusty. This is corpus juris secundum. This is the body of the law. Some law firms that you work at may still have corpus juris secundum in there. American jurisprudence is another one. They're just dictionaries and encyclopedias of the law. Corbin on Contracts is a treatise about law. You could cite to that if you wanted to for principles of what an oral contract is. It'd be considered a secondary source. We need to cite to primary sources though, which are cases. That's okay, Kara. So let's look at a case citation. Yes, go ahead, Adrian.
I just have a question on the paper. You said to give like what we would do if we were the paralegal. Do you want us to write this in like first person as well? Or 'cause usually we're not allowed to.
Yes, all academic, the entire academic community is loosening up on that. You can write in first person, in second person, in third person.
Okay,
I,
good. Okay.
you, they, we. Yeah, that's all
Okay.
good.
Thank you.
If I were the paralegal, I would have done this and I would have sat them down and I would have asked them that. Fine. Yes. I'm really glad that the legal community is loosening up and the academic community is loosening up on that silly rule. First person is fine. Second person is you. That's fine. Third person is they, and that's fine. So what I have highlighted here is a case citation. Leonard versus Pepsi. It's in a federal supplement. If I was to pick up that book, I'd be picking up volume 88. I'd be turning to page 116 where I'd find this case decided by a federal court in New York. The case said the plaintiff's understanding of the commercial as an offer must be rejected. Sometimes commercials that you see on TV or in the newspaper or online, they can be offers if they have specific indefinite terms. But in this case, this New York court said that no objective person could have reasonably concluded that the commercial was actually offering consumers a Harrier jet. So, if the ad says something outrageous, there was one ad that said, "We're bananas for Ford. So if you show up with 2,000 bananas, you can have a Ford." No reasonable person would expect that to create an offer to bring bananas and exchange that for a car. So the reasonable person standard does apply when the court is looking to determine whether an ad is an offer. So if you wanted to cite a case like this in your essay, that'd be fine. You would simply find a case like that by doing research on, Lexis Advance or fast case, and then you would be able to cite to that case. Oh, good. Any questions about this module 1 written assignment? Your paper should be 3 to 5 pages in length with at least 3 references and formatted according to Blue Book standards. So it just is 3 references. So you could cite to a treatise, your lecture notes, the textbook, that's all, or a case, that's all good. Yes, a question about the format of the paper. We got that done. It can be written in first, second, or third person. Great. So just a reminder, we'll have a weekly live session every Wednesday at 6 p.m. It's a chance for us to come together to talk about any questions or issues that you have, for me to try to shed light on contract principles, for us to take a look at the assignment for the week. And as you learn contracts, you should definitely, I have posted a link in the course to flashcards. Did anybody check those out? Did you have a chance to look at the flashcards? Awesome, great. Flashcards were a big help when I was in law school. They were huge, huge help. Tools like that are the reason that I'm here today and not on the side of the street begging. Yes, definitely. Flashcards are the only way I could get through law school, especially classes like this, where there's a lot of terms that you need to memorize. So those flashcards will also help you, in preparing for your paralegal certification exam when that day comes. So great. Any questions or concerns before we wrap up? There is no live session question. There will be a live session question for next week, though. So when this meeting is over, I will send you a link to the recording if you'd like to view it, and I will share this PowerPoint slide with you. If you have any questions or concerns, I'm only an email away, and I will see all of you in cyberspace. Thank you so much for attending. Thanks, Adrian. Thanks, Jody. Thanks, Kara. Thanks, Tina.
I have a question.
Yes.
So I received an email from my advisor saying that we